This courtroom case begins with a shocking accusation. A 71-year-old man, Michael Haley, stands before the court after being found guilty of shooting and killing a man prosecutors say had once helped his own family. But Haley insists the story is far more complicated. He claims the shooting happened because he feared for his life and for his son's safety. Now the courtroom must confront a difficult question: was this a brutal act of violence, or a desperate moment of self-defense? As the prosecutor, defense attorney, and the defendant himself speak, tensions rise and emotions run high. Stay with us, because what unfolds inside this courtroom reveals accusations, contradictions, and a final ruling that will change everything.
And by effectively, unfortunately, killing him in cold blood. There's no sentence this court can impose that will effectively, truly give the victim's family justice. However, as our state legislatures deem this offense which has been committed as a life offense, the court is limited in what it can do.
The prosecutor's statement sets the emotional tone for the case. According to the prosecution, the victim had shown kindness and generosity toward the defendant's family, even allowing his son to live in the home during a difficult time. That detail is important because it paints a picture of betrayal in the eyes of the prosecution. However, the prosecutor also acknowledges a difficult legal reality: the court's sentencing power is limited by state law. No punishment can truly restore the life that was lost, but the judge must still work within the legal framework established by the legislature. This moment highlights the balance courts must maintain between emotional justice for a grieving family and the strict boundaries of the law. What do you think? Should sentencing focus more on the emotional impact of the crime, or strictly on legal guidelines?
This probably came out of Mr. Rolla's office because it only could have. Through Facebook, TikTok, and the local media news, put his thumbs on the scale of justice by promoting and releasing several falsehoods. It's alleged that the trial took so long to be concluded because I tried to fire my attorney at the last minute to postpone the trial, thereby avoiding justice system, and that I was laughing at the justice system. I'd like to point out that I never once asked.
The defense shifts the focus toward Michael Haley's personal circumstances. At 71 years old and reportedly suffering from serious health issues, the defense suggests that any significant prison sentence could effectively become a life sentence. This is a strategy often used during sentencing hearings, reminding the court of the defendant's age, health, and future prospects. The defense also emphasizes that Haley does not accept the jury's verdict and intends to file an appeal, which is his legal right. Appeals are a crucial part of the justice system because they allow higher courts to review whether legal errors occurred during the trial. But emotionally, this moment may feel very different for the victim's family. While the defense talks about mercy and circumstances, they are likely still processing the permanent loss of a loved one.
I would have had to have been evicted. The only witness that the prosecution had was my son, and one friend of Russ's. The summons to my son was sent to a residence that he hadn't lived at since high school. If he hadn't been looking for that summons to appear, he would have not even shown up. I really question how the summons got sent to a Grand Ledge, Michigan address that he hadn't lived at in well over 20 years. That's very strange. Wish I could have a better word to put this, but I would term it shenanigans in losing the thumb drive during the trial and trying to blame it on the court reporter.
As Michael Haley speaks directly to the court, the tone becomes far more personal and confrontational. Instead of focusing only on the events of the shooting, Haley raises serious concerns about the fairness of his trial. He claims that media coverage and social media platforms like Facebook and TikTok spread false information about him before the trial even began. According to Haley, these reports suggested he was trying to delay the trial or mock the justice system. If such claims were true and influenced jurors, it could raise questions about the defendant's right to a fair trial. However, courts typically require strong evidence that jurors were actually exposed to and influenced by media coverage. Without that proof, such arguments rarely succeed. Still, Haley's frustration shows how strongly he believes the system failed him.
I wasn't trying to duck responsibility. I wasn't trying to do anything except point out that I shot Mr. DeLong in fear for my life, and I never contemplated doing anything of the nature until he said that once I was dead, he was going to shoot my son in his head in his sleep. I fail to see how the jury pool could not have been contaminated, at least on a few of the jurors, with this media bliss just before the trial. The facts are, Mr. DeLong kept a handgun in the arm of his chair. As a fact of course, there were guns stashed all over the house. Several guns. I pointed out to the police at the time of the incident that there were illegal full automatic weapon firearms in the house. They never did anything about it. Now, I was never threatened with any of those illegal firearms. It was always with a pistol. But the cops never looked into that, ever. 3 days after the incident, the ex-brother-in-law of the deceased was allowed to come over and remove those weapons from the house. Another thing I disagree with was I repeatedly asked Mr. Brown to do an investigation and go take pictures of the entrance and egress on the house. Had I tried to leave the house before I shot him, the only way to get out of the house was to go past an armed individual that was in between me and the only exit that I was able to use due to my legs of the house. I would have had to go past a man that I honestly believed was armed. And he had previously showed me the weapon and put it back in the arm of the chair. I don't know where it went. I don't know if he had time when I went to my bedroom and back to pitch it, move it, or I have no idea. I tried to get Mr. Brown to do an investigation, even to take pictures of the stairway. Unfortunately, there is 16 steps going from the ground up to an elevated deck. I call it the stairs from hell. It's a tough walk. My right to a speedy trial, I feel, was violated, and not by any doing by me. And it was reported in the news, TikTok, and Facebook that I was the one that slowed the trial down, and I was laughing at the Otsego County court system. I think my right to a fair trial was violated by the last minute rush in the news, TikTok, and Facebook. I fail to see how that could not have influenced at least one or more of the jurors. At my age and my condition, my life was not that important to me. But when Mr. Long said after he killed me, he was going to kill my son, that made my decision for me. And I make no apologies for it. This victim statement by the brother that I only now got aware of, I'd like to point out a couple things to Your Honor. Jeffrey DeLong and Russ DeLong had not spoken to each other in almost 20 years. They hated each other. So Russell's quote unquote home, which was never kept in his name to my knowledge, and I was paying the delinquent taxes on it. Not only that, I was paying rent for years, and my son was paying rent too. Mr. Rollo alleged that Mr. DeLong, the deceased Mr. DeLong, had even let my son off on paying rent while he was suffering from cellulitis and couldn't work.
So, Mr. Haley, I'm perfectly willing to hear what you have to say about your case as part of sentencing, but whether you agree with the victim's, his brother's statement or not, I mean, what does that have to do with anything?
Okay, All I wanted to say was, Jeffrey DeLong ended up, due to these circumstances, he ended up the sole beneficiary of the father's estate.
Okay.
And I'm going to quit talking about that.
I just don't understand what that has to do with the punishment that you should receive in this case.
Okay,
I mean,
to cut to the chase,
if you can tell me, yeah.
drug it on so long.
Well, it's not that you're dragging it on, it's that
It has no import.
the victim's brother is entitled to feel however he feels, regardless of how good or bad their relationship. When you have somebody who's a family member who's killed, even if they're estranged and you don't like them, it can affect you. And so it's not that you're dragging things on, it's just what you're saying.
I can understand, Your Honor.
Yeah.
I will just leave it at that, Your Honor, and apologize for misusing your time.
Well, there's nothing to be sorry for. I suspect your attorney's giving you some good advice, which is
To shut up.
well,
Yes, sir. Yes.
none of what you're doing is, to me, it sounds like you're saying, well,
At this point, the judge steps in and begins addressing the defendant's arguments directly. The judge makes it clear that many of the points Haley is raising, such as disagreements about the victim's family relationships or financial issues, have little relevance to the legal question at hand. The central issue is simple but serious: whether the use of deadly force was legally justified. Under self-defense laws, a person must face an immediate and unavoidable threat before using lethal force. According to the judge, the evidence presented during the trial did not show that such a threat existed when the shooting occurred. This moment marks a critical turning point in the hearing. The judge is essentially explaining why the self-defense argument failed in court. Now the proceedings are moving closer to the most serious moment of all, the final sentencing decision.
I think there was one article on the local news that the trial was starting, but I didn't see any of the things that you're discussing, and I'm on Facebook and TikTok and those social media websites. So I don't know how accurate what you're saying is. I didn't see any of that. More importantly than that, though, is the first question that I asked every single prospective juror was whether they had heard anything about this case prior to the trial. And every single one of them said that they hadn't. So to the extent that there was any media coverage, not only did I not see it, but none of the jurors said that they saw it. So even if it happened, if none of them saw it, it didn't affect your trial in any way, because there's no evidence, or was no evidence presented at trial, none that I've ever seen, that Mr. DeLong presented a threat to you at the time that you shot him. He didn't have a gun. He didn't show a gun to you. He didn't point a gun at you. He couldn't have, because no gun was in his chair. So whether he's had possession of a pistol in that chair before or not, and whether you knew about it or not, the fact is, under the law, regardless of whether you think it's good or bad or agree with the law says that that person has to be presenting an imminent danger to you at the time. And him sitting in his chair and threatening to kill you is not enough for you to go get a gun and then shoot him at point blank range and try to justify it by self-defense. I mean, it's just, there's no evidence that would support a self-defense theory in this case. So the fact that Mr. Brown didn't go and take those pictures and didn't explain to the jury that you couldn't have gotten out of the house, none of that even matters, because based on the evidence that I saw at trial, none of it indicated that you were at a point then that your only options were to kill Mr. I'm not going to argue with you about it. I heard everything you had to say. I'm just telling you. The issue with regard to the summons to your son, I don't know what that has to do with anything to do with your guilt or innocence or a self-defense theory. The thumb drive, I mean, if anything, I think that would have hurt Mr. Rolla's case, because it made him look bad in front of the jury, not you. So I don't know how that could have unfairly influenced the jury against you. I don't think you actually felt physically threatened, and you even alluded to it here today. You indicated that your life wasn't that important and you weren't that worried about it. You were more worried about your son. And certainly there was not an adequate basis here for you to use deadly force in defense of your son under the circumstances as they were at the time that you fired the weapon. So I think ultimately you decided that you were done listening to Mr. DeLong, you were tired of his threats, and you were going to end that, and that's exactly what you did. Clearly a circumstance where you decided to take the law into your own hands. You decided to use deadly force when it wasn't justified, and there's really no excuse for you shooting Mr. DeLong at the time and in the way that you did. And so I do think that a lengthy prison sentence is justified by your actions in this case, regardless of your age or your current condition. The law demands that the court mete out the appropriate punishment. And in this case, the court is going to sentence you to 25 years to 50 years in the Michigan Department of Corrections. You do have credit for 265 days served. The court will order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and so you'll be able to raise all the things that you've raised here with me today.
And with that, the courtroom reaches its final conclusion. After listening to the arguments from both sides and reviewing the evidence presented during trial, the judge delivers a powerful and decisive sentence. Michael Haley is sentenced to 25 to 50 years in prison, along with additional financial penalties including victim assessment fees, court costs, and attorney fees. Despite the defendant's claims that he acted out of fear for his life and his son's safety, the court ultimately determined that the legal standard for self-defense was not met. According to the judge, the evidence showed that deadly force was used when it was not legally justified. This case highlights an important principle in the justice system: fear alone is not enough to justify taking a life unless there is an immediate and unavoidable threat. While the defendant still has the right to appeal, the sentence will stand unless a higher court finds a legal error in the trial process. Now we want to hear from you. Do you believe the judge made the right decision in this case, or do you think the defendant's self-defense argument deserved more consideration? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.